Well, I can see it's just about 5 after 12. I want to make sure that everybody can, we can finish on time for everybody, so I'm going to get started and we'll just continue on. So welcome to the Truth About Estate Planning. This is a brief version of a workshop that we give as an introduction to our clients. The Truth About Estate Planning workshop is actually about 3 hours long. We used to give it all together and then discovered that it probably was too long, and so we divided it into 2 parts. Part 1 is about our philosophy and how we do our planning and talks about fees, etc. And Part 2 is more of the technical information that people need to know in order to make good decisions when they're doing their planning. The second part we now have on our website, so if people go to heritagedesignlaw.com, there's a button in the upper right-hand corner where they can click and they can actually go to a page with about 6 YouTube links. And each of them is about 10 or 15 minutes long about various different topics, and these are things that we ask our clients to take a look at before they actually start doing their planning with us. So the Truth About Estate Planning Part 1 is really kind of an introduction. It's centered around some questions that we send out to clients before the orientation. And the questions have to do with selecting and working with an estate planning attorney. So I'll give you a quick glimpse of these. There's a bunch of questions. Now, these are the questions not that our clients ask us, but they're the questions that we think they would ask if they knew what we know. And so since we have these questions, we also have our own answers. And part of the way that the orientation meeting is really structured is so that we can explain to clients why there are these questions and what our answers to them are. And then if they decide they want to work with us, then they can go ahead and work with us. And if they decide that we're crazy and we don't look like what they want to do, they can go ahead. But usually if I do a good job, most of the people who go to one of these orientation meetings decide to go ahead with us and work with us. This is really part of a process, and here you can see a diagram of the process that we follow for our planning. And you can see in the upper left-hand corner, we have the Truth About Estate Planning Part 1 and Part 2. Part 1 typically takes an hour and a half to 2 hours, depending on the number of questions. And then Part 2, of course, is on the web. And then the first step that people do after that is they go to what we call the Discovery Dialogue or Preparatory Meeting. And then we go through the process. After that, we have our conversation with them where we agree to have an attorney-client relationship, and then we go along with the process. So where we are is right here when we're giving the clients the orientation to planning that we think they need. While we're talking, just as a technical introduction, I just want to make sure that everybody mutes their phone because we can get, if I mute you all, then you can't break in, and I do want you to be able to break in so that if you have any questions as I go along, you can ask them. But if you mute yourself, then you can unmute yourself when you want to ask a question or answer a question I might ask. So please mute your phones. You can do that with *6 and unmute yourself with *7, or you can use your mute button on your phone, either way. Also, I should point out that when clients come to this orientation meeting, we give them a fairly substantial workbook of materials that's outlined based on our process, and oftentimes if they go ahead, they use the workbook to get themselves organized and keep organized while they move through the various different phases of their planning. So, if I may, I'd like to ask for your permission to be blunt. And the reason I'm asking for that is this next slide, which basically tells what we think is the truth about estate planning. And that is that most estate plans just don't work. What we mean by that is that most estate plans really do not meet clients' expectations. I'm not saying ours don't, but in many cases, in most cases, what happens is clients have this vision of what's supposed to happen, and it doesn't actually happen. So what we try to do is to find a way so that people can we can help clients do their estate plans so that they actually work. So how would a client, and let me feel free to unmute yourself. I'm going to ask you these questions. How would a client know if their estate plan worked? Any volunteers? Well, I'm going to answer my own question. Actually, the better question is probably when would a client know if their estate plan worked? And that, of course, is after they're gone. So, you know, and if you have any clients who are going to be able to come back after they're gone to tell us whether they think their plan is working, please let me know. We'd love to work with them. But so how would a client know? Well, I think that most people have this vision or this understanding of what they expect, and we call that the snapshot test. So it's like this. If you're up in the clouds after you're gone, you're up in the clouds, and that's the best option as opposed to the alternative. And you're looking down. If all the people that you care about are running around doing the things that you expected them to do, well, that's a plan that works. But if anything else is happening, that's really a plan that's not working. And so most people, when they're thinking about what that would be, have a sort of a vague idea of what they expect, and we see it as our job to try to help them bring that into focus, sort of like when you go to the eye doctor. You know, I just did this yesterday. I had a doctor's appointment for my eyes. Had a great appointment. Doctor said my eyes are just great. And you know, they do that thing at the beginning where they say, is this one clearer or is that one clearer? Is this one clearer or is that one clearer? Number one or number two? And so what we try to do is to talk to clients about sharpening that vision that they have and exactly what they do. But you know, if you're playing archery, you can aim at the target and you can shoot the arrow and you know if you hit the target. But you know, in estate planning, most people have a lot of trouble figuring out what is the target. So as you know, I'm a member of the National Network of Estate Planning Attorneys, and the founders of the network came up with this definition of estate planning, which we still use today. And here it is. This is really the target of what the vision is supposed to look like. So I want to control my property while I'm alive and well. And I haven't run into too many clients where their first priority isn't control. And I want to plan for me and my loved ones if I become disabled. And, you know, that's really the only place in estate planning where it's really in it, what's in it for the particular person who's doing the planning. Everything else is about everybody else. And so a lot of people don't have a lot of idea of what it is that they want to do for themselves and their loved ones if they become disabled. And so part of our job is to help them kind of clarify that vision too. And then I want to give what I have to whom I want, when I want, and the way that I want, all while assuring my wisdom is transferred along with the rest of my wealth. And note the word wisdom there. When we're giving this, we have a lot of clients who will sit there and, you know, they get this quizzical look on their face, and they're sitting there saying, wisdom, what kind of wisdom do I have? Well, what we really mean is that kind of life's experience that people have, the understanding of the way things are that they get as they live through their lives and live out their stories. And so we think that that perspective that people have should be incorporated in the way their plan works and how they do it. That's a part of what we believe. Not everybody believes that, but that's part of what we think, and so that's what we try to deal with for our clients. So how do we do that? How do we prioritize those objectives, that target? What do we do? Well, You've probably all seen a triangle of some kind or another, and so this is ours. We call this the estate planning pyramid. And of course, if you're building a pyramid, you want to build from the bottom up. And in our view, the first person, the first thing that we need to deal with is the client themselves. That's me. And you know, if we don't really know who they are and what their stories are, it's really hard for us to get their wisdom and their own perspective into their planning. It's sort of like if you're on an airplane, they'll tell you at the beginning that if there's a drop in pressure, the oxygen mask will come down, and they always tell you, please put yours on first before you help anybody else. And that's kind of the way things are. We really need to know who it is that we're doing the planning for first. And then, of course, the people don't generally do any planning unless they care about somebody. Usually that's their family, or it might be a charity. And so the next rung in the ladder is to talk about their family. And so they want to share their experience and their benefits with their family, so we need to find out who they are and work with them on the perspective of what's going to be good for their family. So then, of course, we spend most of our time when we're working with clients on strategies to preserve their wealth. We're attorneys. We don't do a lot with expanding wealth. So we spend most of our time with strategies to help people preserve their wealth so that their beneficiaries and even themselves can enjoy it and not lose it. We'll talk a little bit about that in a few minutes. And so we spend far less time on expanding wealth, which of course is the world of the financial advisors. Now, here is where we think it's really important for us to be working with financial advisors of various different types, because you spend more of your time on the issue of expanding wealth, and in order to actually make a plan that works completely, we need to do both preserving wealth and expanding wealth. And so that's why we've developed this program that I probably mentioned to each of you on the Heritage Design Partners, so that all of our partners can work together with us in our process, and we're all sort of on the same page. Because often if the client is coordinating their planning and they're expanding their wealth, many times the advisors really just don't talk, and we don't think that really works very well. And so we think our job is to make sure that the client's team that they're putting together, and we'll talk a little bit about team later, includes the financial advisors so that everybody's on the same page. So now I'm going to ask you all a question, and please feel free to raise your hand and answer. What is the easiest piece in a puzzle? If you're working on a puzzle, just a regular paper or cardboard puzzle, what is the easiest piece for you to fill in when you're starting a puzzle? What's the easiest piece? Anybody? Don't forget to unmute yourselves. Well, I don't want to call on anybody, but if I don't hear from anybody, I guess I'll have to answer that question myself. Any ideas? Anyone? Well, usually when we're speaking with attorneys and advisors, the answer that we get is either corners or colors. And that's actually, when I first heard that question, that's the answer that I gave. And every time a member of the National Network gives an orientation meeting to clients, they ask that same question. And what's really interesting is that most advisors and attorneys answer the question by saying colors and corners. The real answer, of course, is the first piece, or another good answer is the last piece. And so that's why that's an interesting question, and the reason that we think attorneys and advisors generally answer it that way is because they see the whole process as trying to solve a problem. And so the problem solver comes into light. And so what particularly attorneys have learned, the problem that attorneys have learned to solve, of course, is what? It's the tax problem. So when people come to see us, they sit down with us and we ask them, what do you have? And if you could add everything up together, what would that all add up to? The clients are having difficulty answering that question. We'll talk a little about why in a few minutes, but the reason we're answering that question is because we're thinking of 3 different potential plans. One is a plan for clients who have more than $5 million, married clients more than $5 million. Another plan is for married clients with less than $5 million, and the third one is for single individuals. And so you can see that when we start asking that kind of question, we're really starting from the issue of saving taxes. Well, if you think about it, if that's our starting point, turn the pyramid upside down and see how stable that's going to be. So really we like to ask the clients, who is the expert in the family about your plan? And we don't really think that's the professionals. They're experts in planning, of course, but the person who's the real expert in the plan is the client. And so what we say to them is, we'd like you to teach us about you and your family, and we'll teach you about planning as it applies to you, and together we'll put together a plan that works, sort of solving that jigsaw problem. So it's really not about, if we're thinking about the 3 different types of plans, we're really thinking about 3 different, let's say, templates for a plan or forms. And so what we're talking about then is really just kind of word processing. In our view, 80 or 90% of planning, most planning that comes out today, is really just glorified word processing. So if we ask clients, well, why don't you just go online and go to LegalZoom or something like that and do an estate plan that way, they'll say, well, I really kind of thought it was responsible to ask an expert about the planning before I made decisions. And if you ask an attorney, many attorneys, that same question, they'll say, well, they don't do that because they don't know how to answer the questions. They don't know which options to pick. And when a person is really saying that, what they're really saying is that they're just doing their own word processing, and they're doing very sophisticated word processing, but that's what it is. Really, the paper is just a stack of paper. It's really about trying to implement what a person's snapshot is, and it's really more about what people do than it is about their and how they put together their instructions than it is about the documents themselves. So from our point of view, what this planning pyramid does is it kind of gives clients a priority about how things are what they should be thinking about, and brings some planning issues into full perspective. So what we're trying to do here is we're trying to contrast 2 different approaches. And what we're saying really is that it's really not about the documents. What it is about the results that the client is looking for. It's about what people do and the results of what they do in terms of what the clients expect. And so most planning shouldn't be document-centered. As a matter of fact, if you took a revocable living trust plan and a will-based plan, and most clients, they're always saying, I want to avoid probate. If you took those 2 plans together, you'd see that they all have the same documents. You have a will, you have a healthcare proxy, you have a durable power of attorney, you have a trust. You might have a trust in the will, or you might have it separately. You have all those documents. Both types of plans have the same stuff, and it's really just a stack of documents. It's really just a set of instructions. So what we think are the keys to an effective estate plan are personalized counseling, and that means that you have to start off with a really great set of instructions, and then proper asset ownership, because You know, if you have a great set of instructions, but the way you own your assets doesn't end up following the outline of what your plan is, then your plan is not going to work. So what we mean, of course, by proper asset ownership is how we title the assets, how beneficiary designations are done for life insurance and for retirement plans, all those various different things. And we spend as much time on designing how the assets are going to be owned as we do on designing how the instructions are going to be put forth in the client's documents. And so then, of course, the third one is a formal review process. And please let me put the emphasis for that on formal. The fundamental problem for most clients is that they realize that we tell them, okay, come back every 3 to 5 years, and of course you all know what happens. They don't. If we leave it up to them, they might not come back for a generation. So what we typically tell people is that they should have a formal review process where their estate plans, their documents are reviewed, their titling of their assets is reviewed, and this means that we want clients to have a commitment to making their plans work. That's what we're working with them to do. So there's that commitment that's important for them to have a plan that works, and a lot of that is centered around the issue of making sure that their assets continue to be owned the way they should based on what their instructions are. And then, of course, there's controlling the transfer process. So if you think about your clients and you think about the following question, how many of you, and this is kind of a rhetorical question, how many of you think that if your favorite client died or any of your clients died tonight, that their family would be prepared? Would they know what to do, how to do it, and how to pay for it? You know, if we ask people to define what prepared means, most people in our experience say that, okay, they know who the attorney is and they know what his telephone number is or her telephone number. So that's what, in my experience, a lot of people think prepared means. But you know, if someone dies, people are in a really serious state of disarray because there's a lot going on, and they're not really thinking about learning about that process. It's not something that's going to be something they can really handle. And in particular, if we ask them the question, how many of you have talked to your estate planning attorneys about how your estate will be charged after you're gone? Most people in the audience will not raise their hand. Okay? So that's because most people really don't think about asking the attorney how they're going to be charged after they're gone. And you know, we've done a lot of research on how that works, and we have a lot of statistics that we give to clients at the orientation meeting. But fundamentally, the basic problem is that people really don't know. And if they go into an attorney's office, the attorney will say, okay, here's what we're going to do, here's how we're going to do it, and here's how you're going to pay for it. At that point, they really haven't got any leverage. So from our point of view, it's really important for them, and particularly the people that they're putting together who are their helpers, and that's their family members, you know, successor trustees, people who deal with disability and that kind of thing. Those people need to have some training and understanding about how things are actually going to be done. So when's the best time for them to find that out? Well, it certainly isn't during the settlement process. I can't think of a more expensive way to do that. So how are they going to know what a fair fee is if they don't know what's supposed to be done and they don't know how to do it? And they certainly aren't going to know how to pay for it. So this is very difficult information, and it's part of what we think they should know to have a really effective estate planning. So the strategy that we recommend is what we call the three-step strategy, and here it is. That's to develop your plan with counseling-oriented planning partners. That's step one. Step two is to commit yourself and your family to a formal and continuous maintenance and education program. And step three is to secure appropriate assistance for you and your family to transfer your wisdom along with the rest of your wealth. So let's talk about that first step here. What we think, again, we should be talking to clients about is their planning goals and the various different types of things that they should do for their planning. So, let's talk about, these are the 5 fundamental personal planning issues that we find most clients need to confront. So let me ask you this question. If you had a catastrophic illness toward the end of your life, how many of you would have an opinion on whether you would like to get care in your own home or in a nursing home or assisted living environment? Now, notice that I didn't ask you what your opinion was, but if we ask this in a group of at an orientation meeting, just about everybody raises their hand. So the reason that we don't ask what the opinion is because when we're doing the documents, that what the people's opinion is generally not included in the documents. So what we're talking about, for example, is a healthcare proxy. The healthcare proxy has a lot of powers in it, and it has a lot of authority in it, and specifically describes how clients are supposed to be, how we're supposed to take care of people if they can't make medical decisions for themselves. But it doesn't have the specific instructions about what the client would want to have. What's supposed to happen, and we've actually talked to medical professionals about this, they would prefer only to have a spokesman on behalf of the family or the patient rather than to have to parse specific instructions, because generally those instructions don't specifically apply to the situation. So what's most important for clients is that they actually have a conversation about what they want with the people who are going to be making those decisions. And this may be a little bit revolutionary, but from my point of view, if I had to make a choice between having that conversation and having the document, it would be better, as far as I'm concerned, to have the conversation. Because what happens is that if I'm on my deathbed, or I'm on the bed and the doctors are trying to decide what to do about turning off the machines, they turn to the family and they talk to the family. And at that particular point, not too many people are going to look for the paperwork about who my healthcare proxy is. They will often go by what the instructions of the family are anyway. And so, it's more important to have those instructions discussed with the family than to have the document. But, if you could have both, isn't that better? So, in catastrophic illness, it's really important for people to get the opportunity to talk to family. And it's very, if we gave them a piece of paper and said, okay, write out your instructions, we would probably get blank pieces of paper back. So what we often do is we give them a checklist so that they can actually think about the various different instructions that they would like to give and check things off that apply to them, and then that typically will provoke some kind of extra instruction. So we give them a checklist for that. So then, of course, there's remarriage protection. Everybody knows, when people come to when couples come to an orientation meeting, they're both sitting there, and they're not concerned really about their own divorce. What they're concerned about is if one of them dies and the surviving spouse is going along, they're worried about the influence of that unknown third party. And so there's a lot of things that we can do to protect the surviving spouse and protect the decedent's property from being inappropriately obtained by the subsequent person through divorces or whatever it might be. And there's a lot of things that we can talk to clients about that are options. But, if people don't know what those options are, they can't make a choice between them. And so that's what we really mean by counseling. In order for them to actually make good decisions, they have to know what the options will be, and then they can go ahead and make some good instructions about that particular type of situation. Now, for creditor protection, we have a story called the school bus story. And there's two things that you have to remember about the school bus story before I begin. One of them is that it's hypothetical because in the story, I die. All right, so please remember, I die, and I'm survived by my lovely wife. And what happens in the school bus story happens with her. The second thing that you need to remember is that if you transfer property to a trust, whether it's irrevocable or revocable, if you transfer your property to a trust, you can't then turn around to your creditors and say, no, you can't have that property. That property is unavailable to you. That's called a self-settled trust, and whether it's revocable or irrevocable, a creditor can get to it. So here's the story. After I die, my wife is driving down the street, and it's a rainy day. It's a couple years later, and she decides that she wants to change the channel, and she's a little bit distracted, so she looks down. And then when she looks up again, there's a big yellow school bus right in front of her, and she slams right into it. And then, of course, there's all those children that are injured, and Channel 5 shows up, and there's pictures on the news. It shows up on CNN because it was a big accident. So if you think about that, all that property when I died, let's say that if I gave it to her outright, let's say I had a will that said I give all my property to my spouse if she survives me, then it goes through probate. If that's my instructions, it went through probate. My plan worked the way I expected it to do, but now she has it. And so what do you suppose happens to all that property? Well, of course, the plaintiffs can take it away if they get a judgment, which is not a good result for her. But you know, my wife is a very smart woman, so she heard about doing revocable living trust plans and has transferred all the assets that I gave to her through my probate into her own revocable living trust. The only problem is, as I told you, she can't protect those assets herself from her creditors, particularly the school bus creditors, by transferring property to a trust that she creates. So again, all that property that I left for her, whether it was, however it might have been left to her, that's available to her creditors. What about life insurance proceeds? Well, that goes by a beneficiary designation, not by a will or a trust. But again, who's the beneficiary of my life insurance? Well, that would be her. So she gets the proceeds outright after I die, and so those again are available to her, all of her creditors, because she owns them. But here's another option. Suppose that in my I did a living trust, and in my estate plan, I left the property in a way so that she had she had practical access to it and practical control over the property, either by herself or with somebody else, but it did not belong to her. It's my property. I put it in a trust, and my trust is now irrevocable, and she's the beneficiary of it. Well, in that circumstance, those assets are not available to her creditors. So what I've done then is I protected all those assets for her, even though she has some practical control and she has access to them, they aren't hers. So that's how I can protect the assets for her. So if I'm having a session with some clients, my next question to them is, how many of you would like to leave your property that way? And many of them would say, gee, that sounds like a great idea. And then, of course, the next question is, how many of you have ever been asked that question? And then many times, not too many people raise their hands. And that shows the whole issue of whether people are really getting counseling as opposed to word processing for their plans. If they don't know the options are available, then they can't exercise those options. They can't choose them. Divorce protection really is just another form of remarriage protection. It's a kind of creditor protection for beneficiaries. to avoid them losing property in a divorce. And then, you know, there's one other thing called values promotion. I like to tell the school buff. I like to tell a story about babysitter instructions. And you know, if you have children and you've gone out for the first time and left your children with a babysitter, you know, you spend a lot of time in instructions for that, telling them how you want the children to be treated, how you want them to, when they need to go to bed, what stories to read to them. But, you know, I did that, and my wife and I did that. But what we left out was always what was supposed to happen if we didn't come home. And so, you know, that's really, if we're going away for a lifetime, isn't it important to leave those instructions for our beneficiaries about how we think life should go for them, how important education might be, and all that kind of thing. So those are some short versions of personal planning goals. So the second step is to commit yourself and your family to a formal and continuous maintenance and education program. So what does that mean? Well, there are really three types of change, and we call those lifelong learning. There's changes in people's personal situation, both personal and financial. There are changes in the law, and we've all seen lots of changes in the law over the last 10 or 15 years, particularly estate tax law. But there's also changes in non-tax law, particularly with regard to personal protections. Many states have adopted the Uniform Trust Code, which gets away from the kind of protection that we can often give to families in a trust. And fortunately, Massachusetts passed it but did not include those provisions recently. And then there's the issue of learning. You know, if I did a plan 5 or 10 years ago, I did the best job I possibly could. And, you know, then during the interim period, I've gone to National Network meetings. We do that about every 6 months to learn new stuff, learn new strategies, share our experiences. And so if I do a plan today as compared to the one I did for somebody 5 years ago, which plan would you pick as being the better plan? So, you know, lawyers learn as they go along, and they earn experience as well as they learn new things. And clients learn things as they go along. That's part of the wisdom that they develop. So in order to meet those kinds of changes, we need to do things like having a formal updating program. And what that really includes, of course, is, you know, updating the documents every other year, making sure that the titling to the assets is correct every year. And in our program, when people have a change in how they're going to own their assets, we do that for them, so we're sure that everything is correctly titled. And we have annual client meetings with them to go over things that we're watching the law, things that we're concerned about, what we're doing as changes for our documents, and things that they should be thinking about as well, status of the firm, etc. Excuse me. And of course, the final part is the education part of the program, and that is what we call nuts and bolts. So when I meet with you, I can talk to you all about that. But then, of course, the final thing is securing appropriate assistance and for you and your family to transfer your wisdom along with the rest of your wealth. Now, to understand how that works, there's three factors of overall cost. There's the cost of the documents. That's the part up front. The cost of updating or failing to update. And, of course, it does cost money to update. And, of course, the cost after death. And that, again, the issue for that is how would people know what they're supposed to do, how they're supposed to pay for it. And that's the cost of transferring the assets and the cost of the death tax return preparation. And there's a lot that we could talk about, but we don't have a lot of time here about all those various different costs. But those are all the various different things that we think people should consider, not just the upfront cost of the documents. Essentially, our orientation is what's the overall cost of a plan, and if we think about things in that way, we can substantially reduce the overall cost of the plan, both during the person's lifetime and when they die. So when people are in our program, we have a cap that's substantially reduced. It's less than half of what typical estate settlement costs are for a probate-oriented plan or even a trust-oriented plan. And that's because we know where everything is, and we have people trained, the family knows what to do and how to do it, and so things go a lot more smoothly. It's not really great for a client to call us up and say somebody died and have us say, well, we're really not quite sure how things are going to go because we don't know where things are. People don't expect that of us. They want us to say, okay, we're all set, we know what's going to happen, come on in, we'll get things started. That's how people can actually have some real security in how their planning works. So that's our three-step strategy in brief. Let me talk to you a little bit about, what's in it for you in a way. There are some various different concepts that we'd like to go over with you because you'll understand when we do why we're looking for advisors, particular types of advisors that we can work with. And the first one is the area of wealth reception. Well, what is wealth reception? Well, every person goes through an era in their life when they're creating wealth, and that usually goes up to somewhere in their 50s and even beyond. And then there's an era when they're thinking about transferring their wealth, and then there's the era of the people that they transfer the wealth to, and that's called the wealth reception era. So it's the receivers of the wealth that we're talking about. So what we're talking to clients about is, when is it okay for the ex-spouse to get the inheritance you leave in a divorce proceeding, the ex-spouse of your children? Or when is it okay for Medicaid to require a spend down of the inheritance you left in order for someone to be able to have a nursing home care? Or when is it okay for catastrophic creditor to get the inheritance you leave for your beneficiaries? Well, most clients will say it's never okay for that. And so that's why when they talk to us, it's not just estate plan, tax planning. They want to leave assets in lifetime trusts, and that's for estates of all sizes, not just substantially wealthy people. And they want divorce, creditor, and illness protection and the ability to leave instructions. So what we're talking about there is we're talking about the wealth reception as the end in mind. If we begin with the end in mind, we generally can have a plan that works. So here's the definition of wealth reception. It's a formal process designed to assure you and your loved ones that your true wealth, both financial and non-financial, is fully realized, efficiently transferred, and effectively received. So what does that mean? Well, the first thing is that if we're working with people, we're looking for people who have a process orientation. And when I meet with you, we'll be talking about something called the Great Relationship Divide. And that talks about the problem of maintaining relationships with our respective clients over long periods of time, so that we can make sure that the planning that they do actually achieves their objectives and meets their expectations. There's the three-step strategy, which we sometimes refer to as the Heritage Design Protocol. There's intentional third-party credibility, and that's we're an intentional third-party credibility organization. We intentionally give the advisors that we work with credibility, assuming, of course, that they earn it, and that's who we work with. And the overarching message is the idea of wealth reception planning. So, you all know who the normal attorneys are. They can be slow. I know we can be non-responsive. If a bill referral is a brother-in-law referral, so an attorney can get a referral from an advisor, and then when the same kind of referral goes out to someone who is an advisor, it goes to the brother-in-law. Oftentimes, attorneys are known as deal killers. And, of course, we can be incomprehensibly smart. So that's what happens when a client, and you can see that going on when an attorney explains something to a client and they turn to you and say, what did he mean? So we try to avoid those pitfalls. And, of course, there are some advisors that it's not hard to tell you we are not the ones that we'd want to work with. but you wouldn't be on this telephone, on this conference call, if we thought anything like that was true about you. So I'm going to skip by that one fairly quickly. So the idea of wealth reception is that we want to share with each other through collegiality. We have a practical orientation through education planning and management of the plans. We try to speak in plain English by using stories like the school bus story when we're teaching clients concepts, and we like to follow the team approach. Now, we have a different approach to we have a different concept of what the team approach means, and I'll be happy to talk to you about that when we meet individually. But essentially, the team approach, the traditional team approach, is what we really refer to as just a referral system, but doesn't really involve interdisciplinary collaboration and integration of processes, which is more what we think is appropriate. And that's what we call interdisciplinary collaboration. So in interdisciplinary collaboration, what we do is we speak to clients about their expectations. We have a process whereby we can provide you and or them with an estate plan review letter. So if clients give us a set of documents, we can go through them. We can give them an assessment of what we think the strengths and weaknesses of their documentation is. If we think their documentation is great, we'll tell them. If we think that there's some things that they need to fix, we'll give them a straight answer about what should be done. And we can give that to you with, if you give us the documents blanked out, we're happy to give that assessment letter to you so you can talk to your clients about them if you want to. And we offer that to clients who come to our workshop or to our orientation meeting if they want it. And then, of course, there's partnering opportunities. So I'd like to talk to you about that. The purpose of these opportunities is to reinforce your relationship with your current clientele. And, of course, every satisfied client generally means a number of other clients that they refer to you. Helping people generating new business and sharing control of the clients. We don't think that's appropriate to be control freaks, and the true, the best clients planning that clients can get is through collaborative planning. So that's what we try to do with intentional third-party credibility is to make sure that clients have everybody on the same page, and that we talk to each other independently of the client so that we are on the same page, and that we can talk to the clients with a consensus approach to what they need. So there are several different opportunities in our process where we intentionally would like to have financial advisors who are working directly with our clients. You saw in the diagram I showed you earlier that the first step in our process is what's called the preparatory meeting. And we have a methodology for training advisors about how to do that. That's the first meeting they typically have with us. It's our discovery dialogue. It's the meeting where we actually sit down, gather all of their information, and start them on the process of getting the information we need to do their funding. We estimate what the fees are. We talk to them about what their history in estate planning is, what their experience has been, what their goals are, who the people are that they would like to play roles so that they can start thinking about that before they actually have to make some decisions. There's the second part of this is something called the financial strategy session, and in that there's something called the financial strategy synchronizer. If you look at this, what this is a kind of a diagram of the phases of a trust. So when someone is alive and well, during phase 2, you'll see that they need lots of different financial services and products, and so that's the kind of thing that we want to make sure clients have when we do their planning with them. We go through an exercise that we sometimes refer to as the spots on the X-ray to make sure that they have the various different things that it's appropriate for them them to have in terms of financial planning, investments, and products and services. Again, when they become disabled, there are lots of such circumstances where they need to have professionally managed assets. They might need short-term disability, long-term disability. If they have a business, there's buy-sell disability insurance, lots of different kinds of things like that, long-term care insurance. And then, of course, after they die, typically their trusts will break down into a marital and family trust if there's a surviving spouse. And the surviving spouse, again, and the trustees of these trusts also need a lot of different services and products and services, including financial planning. Many beneficiaries have never had never had this kind of wealth available to them. It's not theirs, of course, but they still need to do some financial planning because of the various different resources that they have. So, the trustees and the beneficiaries are often family members, and so they all need this kind of help. And then, of course, after the second spouse dies, there is a common trust for minor children that often happens, and then there can be sub-trusts for each of the beneficiaries. And again, they need a lot of financial planning and financial services. So when we do our estate settlement process, and I can show you this when we speak, there's various different parts of that along the way where it's really important for the financial advisors to be involved with the family. So then there's the Heritage Design Learning Solution, and that's our education program, both for introduction to clients and also part of our maintenance program. There's a fairly substantial diagram of that I can show you, but there are a lot of different classes that we give and have available to us from our own work and from the national network. And so it's a way to support our clients and their successor trustees and beneficiaries, so we need to train them, and we have a methodology to teach people about insurance and investments and long-term care and planning, that kind of thing. That's what we've taken to, is doing webinars like this, and our client advisory board has been very enthusiastic about the idea of giving our classes that are available for their children and other helpers online and recording them so that they don't actually have to come to a specific location, because of course many of them are all over the country, and so if they know when and how to access this information, it's a lot easier for them. And that's one of the fundamental problems most clients have, is getting their people who are their helpers and beneficiaries actually involved in knowing what to do and how to do it. So that's part of our program. So we'd like to have advisors who can serve as instructors about various different topics as part of that. There's when we actually talk to clients about designing trusts, there's something called the Trusteeship Customizer, which I can show you at another time. I don't really have time to go through it right now. But that's how we teach clients to figure out who's the best trustee and what jobs the trustees should have for the various different types of things trustees do. There's three basic areas. There's administration, investment, and distribution. Some beneficiaries/trustees have day jobs that put them in a position of being able to do all three, and some have day jobs that put them in the position of being able to only deal with, for example, distributions. And so we need to find a way to delegate this responsibility. It supports retention of the assets, and it means that that we can do plans that work for these beneficiaries. And so here's the customizer right here. So you can see that you might have three different beneficiaries. They all have different, might have the same trusts or the same provisions in their trust, but they have different talents. So Lexi is really very talented, for example, so she can handle doing distribution, administration, and investment decisions along with a co-trustee. And often we have the beneficiary in a CPA or a corporate fiduciary, or delegate the investments to an investment advisor through a delegation process. Lexi, on the other hand, Mike, on the other hand, might not have so much talent at all in any of those things, but would want to have input into distribution. And Matt is kind of in the middle of all of those. So then we have another thing. When we speak to clients, particularly in our initial interview with them, when we're talking to them about our relationship, we want to find out who their advisors are, and sometimes they come to us with advisors that they've listed in their personal information form that we've never met. So we like to ask them about, you know, who those advisors are, and should we include them in their process. And then, of course, that means that we should. And so here's the test. Your relationship with this advisor is so strong that you consider his or her advice or relationship an asset you'd like to pass along as part of your wisdom and wealth. And that's who a real trusted advisor is. So we're looking for our clients, we're asking our clients, who are your trusted advisors? And in many cases, they don't really have somebody that they really truly rely on. So we like to help them find somebody who can be their trusted advisor and help promote that relationship for them as well as the receivers of their wealth. So that's our test for someone, and what we're trying to urge clients to do is to find advisors that they do trust so much that they want to pass that relationship along to the people who receive their wealth. So again, the next step for us would be to individually explore our planning possibilities. I'd like to set up a meeting with each of you, and I'll get in touch with you to do that in the next day or so. Of course, you can also register yourself and or your clients for the next Truth About Estate Planning orientation program. I will tell you that the next one is at the at a place in Wellesley that's called Waterstone. It is a I won't say it's an elderly living, it's a senior living facility, brand new, just about 1.5 years old. They have a wonderful place there, and it's next Tuesday night. We do the Truth About Estate Planning workshop on the second Tuesday of every month at 6:30 p.m. And the one this month is actually at the Waterstone. It's in Wellesley Hills. It's right across the river on Route 16 from 128, so it's really accessible. And so, you know, what we're trying to do is we've got a number of clients who've registered for it now. We have some advisors who referred clients to it so that they can hear the story, and the people at Waterstone are registering as well. So it should be an interesting and entertaining evening for the Truth About Estate Planning program. And so we're really looking forward to that next Tuesday. But in any event, sometime in the future we'll hopefully be meeting, and I'll be calling you in the next day or so. Is there anybody who has any questions? Feel free to unmute yourselves and go ahead and ask any questions that you might have. Well, I don't hear any questions, so we'll get together. I hope you've enjoyed this discussion, this presentation, and I look forward to meeting with you individually, and have a good afternoon. Thanks very much.